Okay.
So you had another story though, Jan-Willem.
I had another one. This was when my wife was working in Portugal. There was she's working in Albufeira, which is a place where there are a lot of British people are living there. And there was a very small, it was a British couple who opened a supermarket, a very small supermarket. I mean, in terms of a surface area, not bigger than my house. And so
but your house is big enough to fit. But your house is big enough to fit peacocks and goats. So
that's true. But see, and since they were targeting, they had a lot of British products which were different from the Portuguese products normally in the supermarkets. And they decided to appeal to the British public, and they called themselves Harrods. H-A-R, one R, O-D-S. So it's clearly a play on words on Harrods, which is this big department store in London. So guess what happened? They got a cease and desist letter from Harrods. They didn't appreciate that at all. So now, interestingly here, Harrods also sells food and groceries and the kind of stuff that you can buy in a supermarket. So they were actually selling a similar type of products. But this store was not, well, didn't resemble the real Harrods at all. It was in a small town, not even on the high street. It was in some side street, and so there was, I would say, risk of confusion nil. And I don't know if the dilution would be the problem, and what their likelihood would be that they would actually have won the case. But similarly to the brewery, what happened was that they changed the name themselves, and they changed the name to Shelf and Fridges.
Shelf and Fridges?
Shelf and Fridges. Shelf, and then in inverted commas, and Fridges. I don't know if you're, apparently they got away with that because there is a supermarket chain in the UK called Selfridges.
I did not know that.
Yeah, I thought you might not know that, but it's so Selfridges is one of the big supermarkets. So that was, would they be getting in trouble there, and what is the likelihood that the court would rule against them in this particular case? Because it also has the aspect of being a bit tongue-in-cheek,
right?
Right. And only the British people living in the area would actually get it, if you see what I mean. Yeah, and they would get the message, oh, you can buy some British products here.
Well, go back to Harrods, first of all. That's a department store? It's not a
Yes. No, it's not a grocery store, but they do have food as well. And you can buy all kinds of, you can basically buy anything there.
Right.
I've been there once, and they have food and vegetables, but you can also buy ancient fossils.
Okay. So I would say that their case of trademark infringement, classic trademark infringement, if of course they're using the mark in, didn't you say it was in Portugal?
In Portugal, yes.
Yeah. Is there a Harrods in Portugal?
Not that I know of.
Yeah, so
it's really associated with this big department store in London.
Right. So two things jump into my head. If number one, I don't know what the trademark laws are in Europe. There's this European trademark, right? I think there's a European trademark, which means your trademark rights apply all over Europe. Is that the basic idea?
No. What I do know is there is an EU trademark.
Yeah, Portugal, the UK.
But also, there is also, for every country, there's also national trademarks.
Right. But unlike patents in Europe, where you have to nationalize in each country, with trademarks, I think you can get an EU trademark that covers all the EU countries, right?
Yes.
Okay, so if they have a registered trademark, it would apply in Portugal, assuming Portugal's part of the EU, and the UK was part of the EU at the
Yeah.
time, right? So they have a better case for trademark infringement, classic trademark infringement, than anti-dilution, because with trademark infringement, you don't have to prove that you have a famous mark. That's one of the things about dilution. I think Hugo Boss would win on that particular element, which is proving you have a famous mark. But I don't know if Harrods would succeed on that. Maybe in the UK, they're very famous. I mean, maybe they're a well-known.
I think they're worldwide very famous.
I've never. Have you heard of them, Ray?
Yeah, I heard of them when there's a place in New York City called Italy. It's like Italy, but with an E.
Yeah.
And the buzz on the street when it was opening was that it was an imitation of Harrods in London.
Okay.
And I had never been to Harrods, but you know, what you described, Jan-Willem, is what Italy essentially is. There's food, vegetables, meat. You can buy like cheeses, but also it's a restaurant, and also it's like a store where you can buy other things. So
in this case, though, let's ignore the anti-dilution and just say trademark infringement. They'd probably have a reasonably good case because they're using the same exact word, except they've made it one D instead of two, right?
No, one R instead of two.
Oh, one R instead of two. Okay.
Yeah.
So and it's in a British area of Portugal, right? So they might have a pretty good case for that. But again, go back to the fact that they can't defend themselves against Harrods, so they're gonna get crushed anyway. And then in terms of anti-dilution, you know, I don't know if they're famous enough, but if they are, they have the same problem. So fundamentally, their biggest problem, I think their case is a lot harder than the Hugo Boss case, because Boss Brewing, I think, would be a much easier case to defend if you have the money than Harrods. But also, they're clearly trying to poke a stick at people. They're trying to stick people's eyes, because first they do Harrods, then they go to this other place that's well known in the UK. They're clearly trying to trade off their brand. I mean, whether it's tongue in cheek, I don't know, but clearly they're trying to get people to say, well, wow, that reminds me of that. And maybe there would be confusion.
That was clearly the intention, is to remind people of that brand, and thereby sort of making clear to their target audience, so to speak, and their target market, that they are selling stuff for a British public.
Right. Yes, exactly. Well, you know, in terms of the big guy and the little guy, it reminds me of my own town here, where Ray also grew up, by the way, Clarence, New York. And there's a company called the Clarence Pizza Company, which, by the way, used to be called the Pizza Inn. But they got a cease and desist letter for a company in Florida, which, as you may know, is probably 2,000 miles away or so, or 1,500 miles.
It's a long drive. It's several days.
I know from doing it, it's 22 and a half hours if you only stop for gas and don't stop for food. But anyway, so there's this little company called the Clarence, or the Pizza Inn in Clarence, New York, which is a little tiny town outside of Buffalo, New York. They got a cease and desist letter. They were forced to either fight, which I think they probably would have. Well, this company actually had a trademark, a federally registered trademark, which for a pizza company, right? So they probably would have lost, because when you have a registered trademark, it gives you constructive use all over the nation. But they had to change their name to Clarence Pizza Company, which personally I think is a better name. But anyway, once again, they couldn't fight. And it all comes down to this. Other than your friends in Portugal with Harrods, who really wanted to poke a stick in their eye, they wanted to do that. Other than them, you should do searches. You should do the freedom to operate searches before you pick a name. It would not have helped Boss Brewing, though, because who would have thought, after doing a freedom to operate search, that Hugo Boss would create a problem for Boss Brewing, right? No one would have thought that. So.
Now, what if they had registered? Because I know that with trademark, you register them in certain classes.
Right. Yeah.
Yeah. So certain goods and services. Now, if they had their trademark registered, and let's assume that at that time, because I know you can have an opposition against the trademark for a certain period of time, But
Right.
let's assume it had escaped the attention of the eagle-eyed lawyers at Hugo Boss.
Right.
So they would have had a granted trademark for Boss Brewery. Would it have been much easier for them to defend them in court against the cease and desist letter and against Hugo Boss? Or would that have made no difference?
Yeah, it probably would have made no difference. But here's the thing. Think about it this way. Look at patents for a moment, because I know you're a patent expert. If you have a patent and I have a patent, I could still be committing patent infringement if I go to the marketplace if your patent is broader than mine, right?
Yeah.
If I have a patented product, it doesn't give me the right to go to the market with it. Trademark registration, though, should give you the right. And then what would probably happen is you still have your anti-dilution action, because you might get the mark Boss Brewing and the person doing the examination did not consider the anti-dilution aspects of it, because these people are not experts in everything, right?
Mm-hmm.
By the way, there is no anti-dilution. Let's ignore that fact for the moment.
Yeah.
But then I would say that there would probably still be a trademark infringement action, and maybe there'd be an invalidation of the Boss Brewing mark if it got to that point and if they were right. But I would say that it would not have changed the outcome one bit. And the primary reason for that is money. And as Ray and I have talked about on many of these podcasts, there is the law and then there's money. And if you have the money, you pretty much can do not anything you want, because there are cases where lawyers will take matters on a contingent basis and attack somebody for patent infringement or trademark infringement and take a third.
Not in Europe. Not in Europe.
Oh, they can't do that in Europe. Wow.
Well, I do not know about I don't know about the UK, but I do know that in the Netherlands it's illegal for lawyers to work on a contingent basis. So they cannot.
To me, that's unfortunate, because the advantage of the contingent only case, I mean, personal injury lawyers in the US get a bad reputation, right? Because they're, but here's the reality. If you have to pay a lawyer, you will almost never get justice if you're a little guy. Never. The only hope people have to enter the justice system, I mean, in a civil action, is with contingent only lawyers. You take out the personal injury lawyers. There's even patent lawyers that will take cases on a contingent only basis in the US. Used to be a big thing. There was these patent trolls out there. They're pretty much dying out. But it's the only way people can get redress. It's the only way people can get into the courtroom if you don't have a lot of money. The Boss Brewing Company couldn't sue anybody for trademark infringement or patent infringement or personal injury if they didn't have contingent only lawyers. So that's unfortunate. But you'll never get one to defend you, because if you're just defending yourself, there's no money in it. You can never be a lawyer.
In Europe, the situation is that in a lot of cases that if you win a case, a court will, in a judgment, will say that the other party has to pay your costs.
Yeah, and in the U.S., that's the case as well, but it's not that normal. It's not.
See, that was my question is in this, because in this case with the Boss Brewing Company, it seems like it's not so clear cut and dry. I mean, obviously Hugo Boss has the power here, but it's a totally different product. The trademark doesn't even look that similar, and I'll put them on screen actually when we release this. But so, you know, is there some kind of safeguard in place to prevent these big companies from bossing these people around, these smaller companies around? In this case, literally. And Jan-Willem, you mentioned that you could recover damages in some places, at least, for legal fees. But what about the lost opportunity, you know, and maybe having to cease and desist for a period of time, or you know, having to focus all of your energy on defending yourself and not running your business?
You will never get that back. That is one of the things also which I believe in patent infringement. When you have a case of patent infringement, you will have your best people and your best technical people to support a particular case. And in the end, it means that you don't use those particular people to do the best innovation you could have done.
Yeah, right, exactly. Yeah, you'll never get that.
You never get that paid. I don't think so.
Legal fees more likely in the EU than they do in the US. Maybe they give legal more, but even that, it's such a risk because what lawyer is going to take a case? Maybe this case you might take, but it has to be a frivolous action to get legal fees probably. If it's a legitimate action, you're not going to get legal fees. It's only probably in the cases where it's just totally clearly bullying or frivolous or something like that. So I think you'd be hard pressed. But again, if it wasn't for this global pandemic, Boss Brewing would have a benefit of all this advertising. I had this friend that owned a company called the Buffalo Beast. It was a Buffalo newspaper, and he sold his trademark rights to the Daily Beast. And then he kept using his trademark. And every time they'd threaten him or sue him, he would bring that up and he would get all kinds of publicity around the fact. He would show the complaints against them, like he was getting a ton of publicity with all this litigation. And that's kind of what I feel like here is that Hugo Boss might have helped the Boss Brewing Company more than they hurt the Boss Brewing Company. Because look, in the end, they spent 20,000 pounds. They had to change Boss Black to Boss Brewing Black. Who gives a crap? And also Boss to Bossy, probably better name anyway. So they didn't really lose that much other than the 20,000 pounds, but they got all kinds of fame. They probably post the complaint up there on their wall. They talk about it all the time with their customers.
Yeah.
And then Joe Lysette changing his name over them. I mean, they did pretty well.
By the way, he has changed the last story. He has changed his name back to Joe Lysette.
Yeah, I saw that. He changed it in like May 3rd or March 3rd or something. Changed it back by like April 20th or something.
Yeah.
He benefited too because he got a lot of fame and recognition because we are talking about it. This is the most famous podcast on earth. Billions of people are watching our podcast. And Joe, wait, did I say billions or dozens? I can't remember.
Oh, yeah, well, somewhere in between, I think.
That's right. That's right. But people are talking about it. So Joe Lysette wins too.
Yeah.
And even Boss wins because they ended up looking like, we'll give in, and they actually, it almost like this is a win-win-win. People
it doesn't happen very much in these. Although I don't think it's a win-win for Hugo Boss because they look like idiots and they look like the bad guy harassing small companies. And they probably also spent 20,000 pounds. Probably more actually.
Yeah, they probably spent 3 times that.
Yeah, because they have more expensive lawyers.
Exactly. That's right. I'm sure Hugo Boss lawyers are pretty expensive.
Yeah.
Well, I think this was a really great episode, and Jan-Willem, really appreciate you bringing both of these stories to our attention. Really interesting. I hope that the viewers out there like them. So we'll wrap this up, and we'll just say thanks everyone for tuning in. And if you enjoyed listening to us talk about trademarks and trademark infringement today, please like, comment, and subscribe, and share the podcast with your friends.